Okay, so I'm going to get started here. And again, thank you to the Charleston branch of the NAACP for having me. Again, I'm starting with Amendment 1. This is the clarification of the judiciary's role in impeachment amendment. And in full disclosure, the ACLU does have a position on this amendment. We oppose it, and I'll get into why that is a little bit later on here in the presentation. But we'll go ahead and get started with talking about what it is and why it's been proposed. Oh, already going too far. Bear with me here. Let me get us back. All right. Start this thing over. Technology, isn't it great? All right. My apologies. There we go. Okay. There we go. So we're going to start at the beginning, despite my running through the whole thing already. We're going to start just by looking at what the text of the amendment says. And this is the proposed amendment. So this is what would actually look like in our state constitution if it were to be changed. Anything where you see anything that's struck through, that's language that would be taken out. Anything that you see underlined is new language. And as you can see, most of what's being changed, a lot of what's being changed is just updating terms to make the Constitution comport with how we speak in modern times. The key thing, though, where the rubber hits the road is this bottom sentence, this last sentence that says, no court of this state has any authority or jurisdiction by writ or otherwise to intercede or intervene in or interfere with any impeachment proceedings of the House of Delegates or the Senate conducted hereunder, nor is any judgment rendered by the Senate following a trial of impeachment reviewable by any state of the court. So, of course, when you go and vote on the amendment, the ballot isn't going to have the full text of the amendment. It's not going to have the full text there for you. Instead, it'll summarize what the amendment says. So the summary that'll be included in the ballot is what you see here on the screen. So this is what should say on the ballot. Clarifying that courts have no authority or jurisdiction to intercede or intervene or interfere with impeachment proceedings of the House of Delegates or the Senate, and specifying that a judgment rendered by the Senate following an impeachment trial is not reviewable by any court of the state. That's what you'll actually see on the ballot. It's a pretty basic summary that slightly simplifies the language that we saw that'll be added. And at its core, it's a pretty straightforward amendment. It says the court can't get involved in impeachment proceedings. They can't stop or intervene in the House of Delegates, and they can't review a judgment by the Senate. And before I dive a little bit deeper into the ramifications of that, I want to back up and explore a little bit about why this amendment is being offered. So if you followed West Virginia politics at all in the last 5 years, this is probably a story you're at least somewhat familiar with. But for anyone who hasn't or who just wants a refresher, this is a brief, and I tried to keep it as brief as I could, summary of what happened. And there is some political background to this, and that's important for understanding sort of the broader context. So you have to start back in 2016, when the West Virginia legislature switched from 80 years of Democratic control to control by the Republicans. And at that time, many positions in both the Board of Public Works and in the state Supreme Court were still held by either Democrats or people who had Democratic leanings. And they were sometimes a barrier to some of the major Republican policy priorities. For example, the West Virginia Supreme Court of Appeals, which has 5 sitting justices, had 3 who had at least Democratic leanings and 2 who were more Republican leaning. So with that background, in 2017, news began to emerge about then West Virginia Supreme Court of Appeals Justice Alan Lawfrey and misuse of state resources. Notably, he was found using state money and state personnel to have a couch that belonged to the state Supreme Court removed from his house. There was an attempt to impeach him in 2018 by Democrats, but that was not taken up. And at least some of the reason may have been that Lawfrey is one of the justices who was considered Republican leaning. However, throughout 2018, more revelations came to light about misuse of funds and lavish spending by a number of the Supreme Court justices. So by June of 2018, it got to the point that Governor Justice felt he had to call a special session to initiate impeachment proceedings, and the House approved an investigation. And although these proceedings initially focused on Justice Lawfrey, soon the entire court was brought into the investigation. So on July 11th, slightly before the formal impeachment proceedings really began, Justice Ketchum resigned. He would later plead guilty to personal use of a state vehicle and misuse of a state gas card. After the House Judiciary Committee conducted an investigation, Democrats in the committee recommended impeachment of Justice Lawfrey. However, in the end, a divided committee passed articles of impeachment against all 4 sitting justices. Again, one of them had already resigned at that point. The House eventually adopted those articles, and that's to say that they formally impeached all of those justices. However, it is worth noting that only the impeachment against Justice Lawfrey were unanimous or even close to unanimous. For all the other justices, it was a much more divided vote. And a brief reminder here, just to step back, impeachment doesn't actually remove someone from office. Impeachment is just sort of a formal recognition of wrongdoing. It's the judgment done by the Senate that can remove someone from office or impose other penalties. So that's what happened up to that point. After the House impeached the justices, but before the Senate began deliberations on judgments, Justice Davis resigned. Now, as the Senate began deliberations about judgments, several things kind of happened all about the same period of time. The Senate rejected a motion to censure. It's a formal reprimand, but not removal. Both Justice Workman, who's considered Democratic leaning, and Justice Walker, who's considered Republican leaning. About the same time, Justice Workman filed a suit about the process. While judgment deliberations were going on against Justice Walker, they were delayed for Justice Workman because of these court actions. The Senate eventually decided to censure Justice Walker. Again, it's notable because when there was a proposal to take the same action with a Democratic-leaning justice, they refused to do so. Ultimately, though, Justice Workman's suit was successful, and the courts halted proceedings against all of the remaining justices, including then resigned Justice Davis. They were continuing to try to impose a judgment against her because she had been impeached by the House. The courts halted that as well. A new special session was called at that point to consider impeachment against Justice Lawfrey, who subsequently resigned and was later convicted in federal court. So in the end, the fallout of all this, there were 3 Supreme Court seats that opened up. And as some of my friends here, I know Julie in particular could tell you a whole lot, Julie Archer could tell you a whole lot about this. That ensuing election became a hotbed for political dark money and really a dramatic remaking of the state Supreme Court. There were also attempts between that time period and where we are now to pass this amendment. But it took a supermajority taking over in 2021 before the Republicans had the requisite 2/3 votes in each chamber to put this amendment on the ballot. So this has been an issue ever since all of these impeachment proceedings took place. So through that history, we can kind of understand what drove this amendment. It was the legislature's attempt to impeach justices of the state Supreme Court that was stopped because of court intervention. Now, the legislature felt that they couldn't perform one of the checks they have on the other government branches because another branch got involved. And it's further complicated because the branch that got involved, the branch that intervened, was the branch facing the impeachment proceedings. Now, I want to point, this is a really unusual situation. Impeachment of judicial officials is pretty rare throughout all American jurisdictions. And that's a point that some of the opponents of the amendment have made. This isn't really a necessary amendment because it was such a unique situation. Again, it's pretty rare to impeach judicial officials, and it's virtually unheard of that an entire high court would face impeachment at the same time. It's also unusual because it's rare for courts to intervene in impeachment at all. Again, as proponents of this amendment will tell you, impeachment is a political, not a legal process. So despite the fact that impeachment follows a process that looks like a criminal proceeding, it's not actually a criminal proceeding. And in fact, in the past, courts have often declined to get involved in impeachment proceedings for that reason. It's a general rule that courts have not to get involved in controversies that are political and not legal. So it's one of the things that people said, hey, look, this is a political thing, courts don't have to get involved. And it's also, and this is why I mentioned all the politics as we went through this, because it's impossible in this situation to ignore the politics of it. After a swing in party control, the impeachment proceeding was used in a way that would clear the state Supreme Court and could and actually did allow for an ideological remake of the court that was more in line with the legislature. Now, I'm not saying that was the actual intent of the people who played roles in this saga, but regardless of that intent, the appearance of partisanship tainted the whole process. And it did raise a lot of concerns that without intervention from the court, an even more dramatic shift could have been possible and could be used in this way in the future. So I mentioned at the beginning of the presentation that the ACLU of West Virginia opposes this amendment. And to a small degree, our opposition is rooted in the concern for partisan abuse. Although again, I want to go back and say, we do recognize impeachment is a political process and courts are generally right to avoid making rulings in those situations. But what we oppose is the complete lack of control. So the basic rules for impeachment and the possible judgments that can be given after an impeachment by the Senate are rooted in the West Virginia Constitution. And in matters of constitutional interpretation and in constitutional enforcement, we look to the courts. That is the court's role. So if you fully remove the court's authority to get involved in any impeachment or any judgment, you limit the court's ability to ensure that those basic rules, even those ground rules, are followed. So in the most extreme example, a hyper-partisan legislature could bypass all procedural safeguards and impeach an official who crossed their agenda and issue a judgment beyond what's legal. And there would be no recourse, no way to go back and reverse that, no protections for that individual or for our political process more generally, except to hope that the voters would vote them out the next time around. That would be the only hope, and it would be after the fact. It wouldn't change what had already happened. Now, during the legislative process, I do want to be clear, we communicated that this could be remedied, that the proposed amendment had allowed courts to intervene only when the question wasn't exceeding the constitutional authority. They could have done that. It would have been a more limited area where they could have intervened, and that would have taken away our opposition. But absent any protection like that, we see a real potential for abuse that's unlikely, but potentially very, very serious. And so again, that's why the ACLU opposes this amendment. So again, there you go. That's a brief rundown of what the amendment is, where it comes from, and what our position is.